project. So we've lost some time in that way. So I'm going to just continue from where Advocate Bauer to do what I've asked her to do. We're now proceeding to paragraph 1.12 and paragraph 7.12 of the motion and chapter 1, part 1 of the public protector, pages 34 and 48, in paragraphs 89 and 129. I'm just going to quickly go through all the questions that we'll be focusing on here, and then thereafter ask evidence leaders to just remind us about those issues of scope and so on. The first question is, what was the scope of the investigation in the provisional report? What was the scope of the investigation in the final lifeboat report? Did the scope change between the two reports? If so, did that change materially broaden the scope of the investigation? If the scope materially broadened, which parties were affected? If so, did Advocate Mkhwebane give notice of the broadened scope of investigation to those parties? If Advocate Mkhwebane materially broadened the scope of investigation, did she fail to furnish an explanation for her conduct? We'll be dealing with those, but for now, I'm going to ask evidence leaders so that you don't have to answer those questions, but we can refer to where that is, and then members can respond to these questions. Advocate Bauer.
So the should we get that in the screen and the meeting is being right. The factual inquiry principally focused on whether the South African government, National Treasury, and South African Reserve Bank failed to recover public funds through the government by Mkhwebane. The substantive scope of the investigation focused on compliance with the conclusion with the concluded contract with sovereign Mkhwebane laws and prescripts regarding a decision to not recover an alleged amount of 3.2 billion in government bonds used as security in respect of loans made to Mkhwebane allegedly owed to the government of the Republic of South Africa and so on. Second component would be, so that was what was in the provisional report. Now we come to the final report, what we call the lifeboat report, where it's where the following is added. Right? The report in the circumstances seek also to look into reform of the Republic's monetary system in order to realize government's commitment to improving socioeconomic inequalities in society, and solicit an amendment to the Constitution in respect of the South African Reserve Bank to create inclusive economic benefits for the people of South Africa. Chair, just so that we understand the questions and the sub-questions we're asking. We're asking the questions in the context of the opening paragraph of the charges. It says, Advocate Mkhwebane adopted a dismissal, high-handed, biased, and procedurally irrational and unfair approach in the conduct of investigations, in that she did the following: materially broaden the investigation, etc., along those lines. And this must just be the back of their mind. So those are the two provisions, and then there's a factual analysis of the evidence which then follows on until answering the questions until paragraph 129 of the summations.
Okay, thank you, Advocate Bauer. So we sought to make sure that we give you the background so that you don't have to think hard about that. And therefore, the questions you'll have to respond to relates to whether the scope between the two reports would have changed. If it did, was the change material? And if that material, if the scope of material broadened, which parties were affected? If so, did Advocate Mkhwebane give notice of the broadened scope of the investigation to those parties? And if Mkhwebane materially broadened the scope of the investigation, did she fail to furnish an explanation for her conduct? I see the hand of Honorable Mylan.
Thank you, Chairperson. Chair, the first question is about what the scope was, and the scope initially excluded the role, function, and mandate of the South African Reserve Bank, and the final report then included that in its scope. It materially affected the recommendations of the report because the public protector made specific recommendations that addressed competency that lay with Parliament. It lay with the drafters of the Constitution. It was outside the scope of the initial complaint, and it was a very far-reaching change that was proposed purely on the basis of a policy position of the public protector, which role she does not have. She is not the formulator of policy. So I would argue that there was a substantive change and that it was materially affecting a number of respondents, most particularly the South African Reserve Bank and Parliament of South Africa. Now, the kind of follow-on question to that is, were those people who were affected by it consulted in the scope change? Were they brought in and asked for their opinions? And the answer is no. We've heard that the economist that was brought in was from the SSA, that the Reserve Bank were not consulted about the change in the mandate of the bank, and no other economists were consulted. We heard that Mr. Goodson, I don't even want to try and describe him, but he was not certainly a well-regarded economist who could have given impartial advice to the public protector. So I think that the answer to all of those questions is that there was a scope change, it was material, the people that were affected were not consulted, and that the public protector failed in her duty in that regard. Thank you, Chair.
Thank you, Honorable Milam. Any additional inputs? Honorable Olangola, followed by Honorable Lockridge and Honorable Ngosi.
No, Chair, I just want to say Melana, no, Honorable Mela. Thank you.
Thank you, Honorable Olangola agrees with the issues raised by Honorable Milam. Honorable Lockridge.
Chairperson, I'm also not going to repeat. Safe to say that I also agree with Honourable Milam's position on this. Thank you.
You, Honorable Nkosi.
Yeah, I agree. We just have to be specific on the parties that were affected. It's Parliament, there is a bank, it's APSA, and Australia.
Thank you, Honorable Nkosi. Is there any different view? Don't see any further hand, but I do want to ask if there is a different view from the three speakers that have spoken. None. It therefore means that we are of the same mind on these issues, except obviously in the detailing of those affected parties. Thank you very much. Any remarks before we proceed on this from the evidence leaders?
It's just a fourth component to it, which is from paragraph 121 of the summation, is whether Advocate Mkhwebane failed to furnish an explanation for her conduct.
Honorable Milam did respond to it in saying she failed, and the members who agreed with the NF supported that. You missed just that one. Thank you. No, the chair is here for that. Thank you. If there's no further comment on your part, would like to proceed to the next, and I'm going to invite you to do the same as we do that, so that we take it step by step. We're now proceeding to paragraph 1.11 of the motion and chapter 1, part 1 of the evidence summation, pages 26 and 34, and paragraphs 58 up to 88. It's Advocate Bauer was doing this too. We're now on paragraph 1.1.3. Okay. Yes. Yes. Chapter 1, part 1, pages 48 to 66, paragraph 130 to 181. And the issues we need to be looking at before I invite the evidence leaders is, what was the remedial action proposed in the provisional report? What was the remedial action imposed in the final lifeboat report? Did Advocate Mkhwebane materially alter the remedial action in the final lifeboat report from what was contained in the provisional report? If so, did Advocate Mkhwebane make the alteration on the instruction / advice of the presidency or the SSAA? If Advocate Mkhwebane materially altered any part of the remedial action, did the alterations require that any affected persons be afforded notice thereof and an opportunity to comment? If so, did Advocate Mkhwebane fail to give such affected persons notice or an opportunity to comment? I'm going to invite Advocate Mayosi so that we are also assisted around issues that might have forgotten, and then we'll invite members to respond to the questions thereafter. Advocate Mayosi.
Thank you, Chair.
With a new card.
Like yours, Chair. Thank you, Chair. So members will see that the charge in this paragraph 1.1.3 call for a comparison between what was contained in the provisional report and what was contained, the remedial action that was in the provisional report and the remedial action that was in the final report. And it also calls for an inquiry into whether those changes were done on the instructions and or advice of the presidency and or the SSA. And thirdly, whether those the changes in that remedial action were done without giving a notice to affected parties and an opportunity to them to comment. Just to remind members for context, the summation as to the comparisons really between the two reports, a proper comparison or very useful comparison is in paragraphs 134.1 up until paragraph 134.5 of the summation. Members will just exactly that. Both reports directed that steps should be taken to recover the interest that had been accrued in ABSA's favor. And then the provisional report directed National Treasury and the SAB to take steps to ensure that the applicable systems, regulations, and policies prevented the recurrence of something similar to what had happened in the lifeboat incident. The final report didn't include such a direction. The provisional report directed National Treasury and SAB to institute legal action against ABSA to recover the accrued interest. The final report then directed the SIU to take steps to allow it to recover that amount of money. The next difference between the provisional and the final report is the provisional report directed the president to consider whether it was necessary to appoint a commission of inquiry to investigate the apartheid corruption alleged in the CIX report, whereas the final report directed the SIU to take steps to investigate the alleged misappropriated public funds given to various institutions as mentioned in the report. The lifeboat report that's the final report. It directed that steps should be taken to amend SAB's mandate as set out in the Constitution, and it prescribed how the Constitution should read after the amendment. In the provisional report, there was no such stipulation. I think I've skipped 134.4. Members will see what it says there. So in short, those are the differences in the comparisons between the two reports. So the questions that the chair then read out earlier then arise from a comparison of those two changes between the remedial actions in the provisional and the remedial action that ultimately ended up in the final report, and how it is that those remedial actions came about and whether the affected persons were notified and given an opportunity to comment. So that's just for the context, Chair.
Thank you. I nearly said honorable. Thank you, Advocate Mayosi. You're not there. I know there are people with some wishes, but honorable members, the context has been given in the summary to clarify the differences. I now want to invite members to, and I would have gone through all of the questions because I think it helps to do that. Before lunch, as we were starting, we were settling into this, but from the last one, it looks like we can do it much better. So I'm inviting if there are any takers and comments on these matters. The issue of what the remedial action proposing the provisional and live vote has been now clarified, context given, issues of material altering, whether the alteration were from an instruction of the presidency or the and the SSA, and so on. Any takers? You also remember what I said. If I don't see a hand, I point out. Okay. Maybe let me. Now I was going to help them one by one, but I see Honorable Milam, please go ahead.
Chair, thank you.
You are invited.
Yeah, I didn't want to be the one to talk to all of these things, but okay. So I think that
No,
the issue here.
Don't worry. We all going to talk and repeat. It's a tedious exercise. Go ahead.
So thank you, Chair. I think the issue here is that the remedial action was vastly different in the final report compared to in the original report, in that it made specific recommendations to amend the Constitution. I think that the role of the SSA, I don't think we can go so far as to say that the president or the SSA instructed the public protector to make changes to the report. I don't believe we have that evidence in front of us, but I do think that she acted on their advice and used words that were provided to her by, for example, Mr. Moody or Dr. Moody at the SSA. So I think we would be stretching it to say that she was instructed, but I do think that there is sufficient evidence to show that she was working alongside them and using wording that was provided by them. And I think I'd leave it there. Thank you, Chair.
Thank you, Honorable Milam. The next person will be Honorable Anneli Lottridge.
Thank you, Chair. I also agree with Honourable Milam in that there is a substantive change in the remedial action in the report, but I also am a bit hesitant in stretching it as to say that it was on the instruction of, but it is quite clear from the evidence that there were discussions, conversations held. If we're looking at what the court found and how Advocate Mkhwebane contradicted herself, that in essence it does come down to that there were discussions with the presidency as well as state security. Thank you.
Thank you, Honorable Lottridge. You also agreeing with Honorable Milam, including on us having to reframe that the instruction comes across as hard and very definite, whereas it could have been issues of leaning towards them or conversation issues. I now recognize Honorable Maneli, followed by Honorable Gondwe and Honorable Nkosi.
No, thanks, Chair. I also agree with what could have been the difference, including the fact that in the provisional report, those that are not consulted with the change of scope were consulted earlier. I think it's important to bring that point that whilst there may have been a right to look at matters, extend the scope, but you need to inform the affected parties so that they also understand when you get to the remedial action what then needs to happen. So without mentioning already what has been mentioned about how Parliament was affected, how bank is affected, and so on, that principle of going back to give them an ear so that they make inputs. I think in as far as it relates to the presidency and the SSA, I think from a point of instruction, indeed, it may be something else. But what we know from a point of record, in as far as what has been led before us, that you'll get also from Kekana in the main. As it related to the presidency, it was to meet the legal people on that side, on the part of remedial action. In the which, as we said before, so I'm raising this from a point of consistency, that if the contents of the discussions with the presidents have not been made known, it will not be correct to come to an assumption that there's probably instruction from there. So I just thought it's important to make that point. We do know, again, I'm saying do know because this has not been challenged, Chair, that from Mr. Kekana side is that then a meeting with the SSA was such that even the wording thereof will be assisted from that angle. So when you talk about that part of meeting the SSA, there's also that element there, right? But I would not, as I say it's an instruction from the presidency or the other, but based on what is before the committee, at least that we know that there was a role played, including meeting certain people to even help with the wedding in that regard. So I thought I should raise that. Thanks, Chair.
Thank you, Honorable Maneli, for the contribution. Honorable Gondwe.
I am covered by the previous speakers, but I just wanted to impress upon the fact that we have heard evidence to the effect that there were meetings with the presidency and the SSA and around the involvement of Mr. Mahendra Mudli in terms of the crafting of the remedial action for the ABSA Banco report. So I think the emphasis should be on that we do know that there were meetings with the presidency and the SSA, and we had evidence led, I think, by more than one witness to the effect that Mr. Mahendra Mudli was involved in the crafting of the remedial action. And I tend to agree that indeed the remedial action, varied in the second report as compared to the first one, and to a great extent because now there was, the suggestion that the mandate of the Reserve Bank should be altered. But Chair, I just want to speak also to, the exclusion of certain parties in the whole investigation. And I think Honorable Milam alluded to it earlier to say that the Reserve Bank, and I think to some extent Treasury as well, should have been heard. And also maybe, the banking sector in terms of the remedial action, but that didn't happen. And so the picture that was painted from all the evidence that we heard was that it was the voice of the SSA that came up. And there's no denying that the SSA, you will recall that it was NIA at the time was also involved. They played a role in the whole agreement. But what came across very strongly is that the SSA was more involved than any other party in the whole investigation. Thank you, Chair.